think we're just about 6:05. I think it's a good time to get started. Looks like we're going to have maybe a handful of others trickle in, but I will share the screen and get your PowerPoint ready to go so we can get rolling.
All right.
John, if you want to introduce yourself while I get to that, that'd be great.
Sure. Thank you, James. My name is John Baumel. I'm a supervisor with the Summit County Prosecutor's Office. I've been with Summit County for approximately 12 years. Prior to that, I was with the Stark County Prosecutor's Office for 14 years. And I had an opportunity to talk here at the Citizens Academy last year as well about this subject. And it's a highly relevant subject. It's a controversial subject, and it has been so for quite some time. It's relevant here in our county, in our state, and it's relevant throughout the nation. And I think it hit its pinnacle last summer with the George Floyd case, and seeing how that case went through the system. So I'm going to tell you a little bit, about my background. I mean, one of the interesting aspects now of the Summit County Prosecutor's Office and officer-involved shootings is that procedurally things have changed in the last couple of years, where we used to handle these cases and be hands-on and fully involved from the beginning to the end. But now the Ohio Attorney General's Office has taken on that role. But I do have experience going way back to Stark County in being involved prosecuting police officers for felony conduct. The involvement in officer-involved shootings in that office back in the 90s was not nearly as intensive or involved as it was in Summit County. The way we would handle cases there is that if there was an officer-involved shooting, we would review the case. If we felt that it was worthy to be sent to the grand jury, it would be. If not, there would just be no charges. So there wasn't a lot of transparency. It was just inter-office decisions being made, or if we felt there was enough evidence to go to the grand jury, which is by law a secretive proceeding, the grand jury would just decide. When I switched over here to Summit County, we became much more, it's a much more hands-on process. I was one of about a half a dozen supervisors who would be on call, that if there was an officer-involved shooting, be it any time of day or night, we would be called out, go out to the scene, get a walkthrough with the officers, with anybody who was on scene. Could be any type of weather, could be freezing out, but we would be involved in interviewing police officers, witnesses, reviewing the entire case as the days went on, whether there's video, photographs, ballistic evidence, medical records, and we would ultimately issue a written report, and that written report would be a public record for the public to be able to view and make a decision whether the case should be referred to the grand jury or not. So it was much more transparent, hands-on. And I think we established a protocol that, in fact, the Ohio Attorney General's Office has kind of utilized from this point on. So, I guess one of the last slides I have, and I didn't get to it last year, so I kind of want to start out with that as well, is that in Summit County, when we handled these cases, it was, and it still is, our perspective as to the role of the prosecutor. And it is that the prosecutor has to be an advocate for what is right. The prosecutor in these type of cases especially needs to make a very clear statement to the public that, one, the incident is not going to be prejudged in any direction. There will be no prejudgment beforehand as to whether an officer acted reasonably or unreasonably, or if the person who was a victim of the shooting was in the wrong or in the right. Nothing is going to be judged up front. It's going to be after evaluation of the evidence. Two, a full comprehensive investigation is going to be done to get to the right decision. And three, that when the prosecutor can be transparent about it, they will be transparent about it. The role of police officers, police agencies in these cases have changed also in the last several years. There was a time when we handled these cases where if, for example, if the Akron Police Department had an officer involved shooting, it would be the Akron Police Department that would lead up the investigation. New procedures are now is that the Ohio Attorney General's office pretty much handles everything. They have their own police force, their investigative force, and they conduct the thorough investigation, and it's their attorneys who ultimately would prosecute or make the legal decisions as to whether a police officer should be prosecuted or not. And that's the way to do it. It was even our belief when we were handling these cases, our advice to agencies was to bring in an outside agency to conduct the investigation. Because one, that ensures complete impartiality. Factually it does, as well it gives the appearance of impartiality. And you want to have the public's trust, especially in these type of cases, that there is impartiality going on. So what I can discuss is kind of things that I can tell you about the legal standard, the law, which is what we are bound by. And I can go over a couple cases that I handled prior to the duties being switched. But if this is a subject that really interests you, or if there are events that occur in the future that interest you, the Ohio Attorney General has some really great information on their website. They actually have a book entitled An Officer Involved Critical Incident that is free. You can go on there, the ohioattorneygeneral.gov, and you can sign up and have access to the book, which discusses their protocol, which discusses how they investigate these cases from start to finish. There's also an excellent YouTube video entitled BCI Insights, Investigating Law Enforcement Lethal Use of Force. It's about a half an hour video. And once again, it goes over in detail how they investigate cases in which police have used lethal force in regards to one of their investigation or one of their cases.
Hey, John, it's James again.
Yes.
I did a couple of things. One, can you see, I've shared the screen. Can you see the PowerPoint? Are you okay?
Yes, I can see the PowerPoint.
I wanted to make sure you saw that too. And two, I want to make sure that if anybody has any questions during your presentation, that if they want to just kind of jump in, or if they want to put it in the chat room, please go ahead and do so. We'll keep an eye on things. We'll hopefully be able to get people's questions answered pretty quickly.
Yeah, by all means, if you have questions, you don't need to wait to the end of this presentation. And James, interrupt me if you see there's a question that I don't notice. This whole Zoom and virtual presentations is still a little foreign to me, even though we've been doing it now for over a year. But I don't often give presentations. So another aspect that is extremely significant and helpful in these type of cases is the body-worn cameras that police officers are now equipped with. They have cameras that are equipped on their chest area, that when they get involved in an investigation, they activate those cameras, and those cameras actually go back 30 seconds. But they tape everything then that occurs that can be seen from the chest area of the police officer. And from the beginning, both sides, be it individuals who have had trouble with police in the past, as well as police themselves, we're extremely happy to get these body-worn cameras. For victims of police misconduct or officer-involved shooting, these cases now didn't simply rely on what a police officer said or what other police officers said. We now had documentation, live footage of pretty much everything that occurred, both visually and audially. And same for the police. When they're accused of misconduct, when they're accused of brutality, we now have video to see if the accusations are supported or if they're not supported based upon video. So these body-worn cameras are extremely crucial. Really, they're crucial in all our investigations. But in these officer-involved shootings or accusations of of police misconduct or brutality. They provide really what would be a third-party view, an unbiased view of what occurred.
John, really quick, we do have a question in the chat room from Kathy asking, how long, I guess, duration of time, once an officer turns on their body worn camera, how long does it record? And are officers allowed to shut them off?
It will record until it's shut off. I mean, I've seen body camera video that goes 3 to 4 hours. So once it's on, and they keep it on, it can go on for quite a period of time. These cameras are all utilized based upon the police department's internal policies, and almost all of them have policies as to when you turn it on, and when you're permitted to turn it off based upon the circumstances of their investigation. They also have the ability to turn off the sound. And there are times, once again, it's kind of based upon that agency's policy as to when they're allowed to turn off the sound, and when they're required to keep that sound going. So it depends from agency to agency. But for the most part, if they're actively involved in the investigation, they're not just sitting to the side, chatting with another officer. In any of these cases, they're supposed to have their volume going and their camera on. Another aspect of the body worn cameras is that in just this past summer, a new law was passed in Akron, which requires that videos of deadly force by police be automatically posted online for the public to view within 7 days of the incident. So that is a significant law, because I think people often, after these events occur, one, they want to know answers right away. And I think it adds to the credibility of the investigation that people get information as quick as possible. And as I said, videos, they don't lie. You see what you see. What happened happened. And I think it's helpful for the public to know that if there is an incident of deadly force by the police in Akron, that they are required now to post that video online within 7 days of the incident. So going forward, that's something that you can look forward, if you hear about an incident and you have an interest in how that incident is being investigated, how it's being portrayed, whether it's in the media or by representatives of the police department or our office, you can actually have the ability to go online and see those videos now. So moving on kind of to the meat of the presentation, we start with the law. That's the standard that we go by when we evaluate these cases, and it's not whether we agree or disagree with the law, that's irrelevant. We apply the standard that judges have set. It's similar to self-defense cases. Self-defense cases now, the standard has been changed. In court, it used to be that a person who's charged with an offense and is claiming self-defense, they had the burden to prove it. So a defendant on trial had to prove that they acted in self-defense. Well, that standard has changed. Now it's the prosecutor's office who has to prove, by proof beyond a reasonable doubt, that it was not self-defense. So in fact, in those type of cases now, we have to prove negatively that self-defense did not occur. It's not a standard that I love having. It does provide a burden that we did not have before, but that's the law, and that's what we follow, and that's how we analyze our cases, prosecute our cases, and how juries are instructed by the judge to decide those cases. So if you would, James, next screen, going to the relevant law in cases involving officer involved shooting or officer force. The standard really is, to put it in layman's term, it's that you evaluate these cases on a case-by-case basis, and it's, did the officer act reasonably? Would a reasonable officer acted in this manner? It's not, would Joe Citizen act reasonable because officers are held to a different standard because they have a different role in our society. They have a role and a duty to protect. They have a duty to protect other citizens, and they have a duty to investigate and make arrests of people who are committing crimes. But it goes back to 1989, and this is still the standard, that the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 2020 vision of hindsight. So, there may be cases, and it's often the case where you go back and you say, it's like what you call Monday morning quarterbacking. You could go back and say, well, he could have done this better. He could have done this differently. But you look at the moment under the circumstances and you think, would a reasonable police officer, is that how he acted? Would that be considered reasonable? It doesn't have to be the best course of action. Next slide. With respect to a claim of excessive force, the same standard of reasonableness at the moment applies. Not every push or shove, even if it may later seem unnecessary in the peace of a judge's chambers, violates the Fourth Amendment. Again, they're talking about excessive force. What is excessive? And it comes down to kind of a very generic, general term of reasonableness. Next slide. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. And I think when you get to see some of these body cameras, I think that also is helpful in taking you in the moment. Sometimes with all the media, as far as movies, televisions, video games out there, there's a threat or a concern of people getting desensitized about how intense and life-threatening these situations truly are, and that police officers are put in these situations every day, and they have to make split-second decisions. It doesn't mean that they can get away with acting unreasonably. The hope is that they've been trained and kind of have been vetted so that they're able to handle that type of pressure. But you can't just decide these cases in a complete bubble. You have to really truly appreciate the intense nature and the life-threatening nature to everyone involved with these situations. Next slide. The reasonableness of the use of force is evaluated under an objective inquiry that pays careful attention to the facts and circumstances of each particular case. Once again, it's a case-by-case decision, and you're going to decide this case objectively, that you're not going to allow emotions to come into play, because obviously, there's a tragedy that's occurred, regardless of whose fault it is, regardless of the reasonableness. It's a tragedy, but these cases, as all crimes, and we try to decide how we prosecute cases always objectively and in a case-by-case standard, and these cases are no different. Next slide. Excessive force claims are evaluated for objective reasonableness based upon the information the officers had when the conduct occurred. And so once again, and one of the cases we'll get into here shortly is a case Robert Talbert. Police can have a lot of information or a little bit of information leading up to the time where they use deadly force. They may know a lot about the person, they may know nothing. And once again, we have to put that as one of the factors as to how they acted. Next slide. There might have been. I see Kathy had a question. Has there been changes in the training of how different situations are handled? Are there new strategies trending on what the police can do that do not use force? And there certainly has been. I think that this may be the most analyzed aspect of police work as to the training these officers receive, as also the instruction they receive as to when and how to use deadly force. I know, for example, one of the and there's many, but this is just one example. One highlight factor is, shooting an individual who's in a car, that's frowned upon. That if a person is in the car and he's driving away, a person who is in their vehicle, that is a time where we hope deadly force is not necessary if they're trying to drive away and escape. One of the cases that I might get to is a case though where the suspects were using the car as a weapon, and then that changes things. So once again, it's a case-by-case standard. But I think as more of these cases are analyzed as to whether the police officer acted proper or improper, that ultimately changes how police are confronting this issue and how they're training officers to deal with these issues. So the next case, Robert Talbert, is a case that I handled when we were handling these cases back in August of 2018. The background of this case is that Robert Talbert had shot and killed his ex-wife at about 3:40 in the morning. That report came into the police. The sister-in-law of Talbert, so the sister of the victim, had called the police. Police arrived on the scene. While they were on the scene, Robert Talbert actually called into the sister-in-law, and he told her that he was going to shoot himself, and he also threatened to shoot officers if they approached him at all. The sister-in-law also instructed the officers that she knew that Talbert had some mental health issues, that he was bipolar. And so police immediately are on kind of the lookout, on a big search trying to locate him. But they have that information, and that information then becomes extremely relevant as to how they're going to handle the situation. One of the pieces of information they did not have, which was later learned, is that same morning after Talbert had shot and killed his ex-wife, is that he carjacked an individual at 6:30 a.m. at gunpoint. Next slide. As the morning went on, Talbert is looking for places to hide. He goes into one home at around 6:39 a.m. Confronted by the owner, and he flees. The owner calls the police. The police become aware of that. And then at 9:09, we know that Talbert trespassed into another home on Kohler Avenue. So around 9 in the morning, I think it was a Saturday, police go to the the Kohler Avenue address, and that's where they encounter Robert Talbert. Next slide. You can see from these photos, and once again, this is from a body-worn camera of one of the officers. The house on the left is the house that Mr. Talbert had broken into, kind of in an attempt to hide. The residents were in there and they called the police. The house to the right becomes relevant because when Mr. Talbert comes out, two of the officers involved then in the shooting take cover behind the front steps there, the cement steps that you can see in front of that kind of cream colored house with the maroon shutters. Next slide. This is where the police took cover. And if you look carefully, you can see in the upper left-hand corner in this body camera, you can see Robert Talbert. He's standing in the middle of the street. Like I said, it's around 9:30, I think, at this time on a Saturday. He has the gun actually pointed at his head. Next slide. Trying to do a little bit of close-up of that, but this is what officers are observing: a firearm in his hand, and he has it pointed towards his head. Officers would repeatedly tell or demand Robert Talbert to put down the gun. He did not. He then took the gun away from his head, and it's at that time that two of the officers began shooting. They shot and they killed Mr. Talbert there in the street. The officers indicated based upon their knowledge of his threats to police officers, the threats to shoot himself, his conduct that morning, and really the circumstance right here that it takes less than a second for him to start opening fire. There's other police officers in the area. This is a completely residential neighborhood. Cars could unexpectedly be driving by at that time of day. And the threat then was off the charts at that point. And I wrote a report deeming that they acted reasonably in shooting and ultimately taking the life of Robert Talbert under those circumstances. All right, any questions on that part of the presentation? Another case that I investigated back in 2018, two individuals, Christian Beard and Matthew Burkhart, were both shot. Neither individual died, but they both suffered gunshot wounds and some serious injuries as a result of it. This is one of these cases I was called out at about 5 in the morning. It was freezing cold out. And this case started, next slide. This case started as a report of a theft offense. This is kind of an overhead view of the area. On the right side is a kind of a strip mall. It was a Tractor Supply store. And the Tractor Supply, they keep merchandise outside the store even when they're closed. They kind of keep it chained up. And Christian Beard and Matthew Burkhart had driven by the store in their van. They had gone outside and tried to cut some of these chains when there was actually workers inside the store who were doing inventory, and they called the police. They made some noise, and so Christian Beard and Matthew Burkhart, took off. They went down the street that you can see there, which is really behind the store, and then they took a right, and then you can see kind of a circular driveway, and they parked their van in the circular driveway there, and that house is actually a triplex, I think you call it. It's more than a duplex. There's 3 residences there, but they had security cameras. So we were able to see not only when the police arrived and all their cameras, but we were also able to see security cameras from the residents as to what occurred when police arrived. Next slide. So this is before the police arrived. This is that circular driveway, and there were 2 cars already parked in the driveway for residents, an SUV and maybe a smaller SUV, but you can see the van had pulled up behind the SUV. The lights were out at that time, and that's the van in which Christian Beard and Matthew Burkhart were in. I think they initially, I'm not sure exactly why they stopped at this residence, but they did. They turned their lights out, and I think they were hoping just to remain there and go unnoticed, knowing that the Tractor Supply store had probably called the police, and police were on their way. The police did in fact show up, as you can see from this slide. They had officers from Lakemore Township as well as Springfield Township. One of the police cars pulled up behind the van, and another police car you can see is off to the right and in the road. When they went up to the van, they looked inside and they saw Beard and Burkhart, and Beard and Burkhart tried to feign like they were asleep. So pretended like they were asleep in the vehicle. Police officers knocked, got no response, and so they went and got a Slim Jim since the doors were locked. And it's at that time that the individuals in the van woke up. You can go to the next slide, please. That's the driver, Christian Beard, and the light on him is the police light. And in the top frame, once again, these are all body-worn cameras where we get these images. The top frame is Christian Beard looking at the police officer, and then you can see him looking behind him, because he then starts up the van. Although the police are telling him to unlock the door, to come on out, instead he keeps the door locked. He decides to start up the vehicle and go in reverse, even though there's a police cruiser directly behind him. Next slide. Yeah, this slide's a little blurry, but you can see when the van went backwards into the cruiser, the wheel, it didn't really get very far, and the wheels just start turning, but it caused the van to kind of veer a little bit to the left, and there were police officers there. And so now the van is directly facing the police officers. And two of the police officers then on the other side of the van see Mr. Beard go to put the car into drive. And it's at that time that two officers begin shooting into the vehicle. Next slide. And this is a security footage from the residence. Where it's at this point where you can see one officer with a gun kind of in the forefront of that video. If you look in the front, almost by the street, you see an individual, and that's a police officer who, thinking the van, yep, right there, is running away from the van at that point in fear of it being run over at that point. And so, as I said, the individuals were not killed in the van. It was a little bit more of a complex analysis. The Ohio Attorney General did the investigation, and they have fantastic tools. They were able to kind of take the footage and enhance it and almost take it down to millisecond by millisecond, so we could see exactly what the van was doing and what the police were doing when the shots were fired. One of the complex nature is that the police, based upon where they were located, were shooting through the passenger side of the van at the driver. They started out shooting into the windshield, but then they also shot through the passenger side. And so the passenger was hit as well as the driver, even though it was the driver who had chosen to start the car, run it, and attempt to put it in drive and drive towards the police officers on scene. So in analyzing this, it was my determination that the police officers did act reasonably because of the protecting the lives of the police officers in front of the van, that the individuals had shown that they were going to try to escape no matter what it took. They refused to all the commands to stop the vehicle, or to actually unlock the vehicle and get out, and instead started the vehicle and began attempts to drive it at the police officers. A little side note, though, is that there is, I think it's still pending, a significant civil lawsuit that was filed by the two individuals who were shot. And yes, I saw one of the questions is, were they high? They had, because of their injuries and the blood loss, we don't know for sure in their blood, but there was drugs, methamphetamines, I believe it was found in the van. And there was also a witness who had been with them. I think it was the owner of the van, who said they had kind of been on a binge, ingesting drugs for an entire day or so. So there was evidence as well that Beard, definitely Beard, and possibly Burkhart as well, were on drugs. But once again, we applied the standard. How would a reasonable officer put them in this place? Was it reasonable as to how they acted? And it was determined that yes, indeed, it was reasonable, and there was no need to take this case and potentially charge the officers for their conduct. Okay. I mean, the question is, how can the criminals sue civilly when they were in the middle of the act of a crime? And I mean, it's a good question. They're suing civilly, and their claim and the standard, I believe, and I'm not a civil attorney, I think it's a little bit different, is whether the police officers were acting recklessly. As they say, anybody can sue. You can always file a lawsuit, but if it's frivolous or there's nothing to support it, the judge hopefully will throw it out right away. In this case, I'm not sure what the passenger's view is. The passenger did not decide to start the car or do anything with the car other than he was acting in concert as far as committing a theft offense and pretending to be asleep and not unlocking the door. But my hope is that they're not successful civilly, and I hope there's no but lots of time these things settle, but they still, even though they committed that crime, they can still file a lawsuit. But whether it's successful is a whole nother, another question. And the fact that they were in the middle of crimes, the fact that they were high on drugs will also play into all of that. All right, next one. All right, so George Floyd Jr., those were the two cases.
Not in Orange County, where there is growing outrage over a.
Oh, and we'll get to that one in a second.
Sorry, I hit it twice. I apologize.
That's all right. But George Floyd kind of, showed us a case, and most every prosecutor I talk to, sometimes you can just see a video, and it's an easy determination as to whether the officers acted reasonably or not. And I think George Floyd was a case where, as a prosecutor, just watching the video as to how the arresting officer acted in that case, that it was not reasonable, that he had gone beyond any sense of reasonableness that you would expect from an officer, from any reasonable officer, and that there was no need for the conduct to secure the safety of either other officers or people of the public. And and as far as that for that officer, the justice system did work in that he was charged, he was prosecuted, and he was sentenced for that conduct. And so, but once again, they're looking at the same standard as the standard I've talked about in these other cases. And I think universally, nationally, when you see these cases, they can be extremely, emotional and frustrating to individuals who see that and they believe that police are not acting properly. And the hope is that everyone involved, the investigation and the prosecutors, are being fair, are not prejudging, are being transparent as much as they possibly can, and making the correct call under the law. So the Stephon Clark case, I'll tell you a little bit about it before we get on the video. This also occurred 2018. He was shot and killed in his grandmother's backyard in Sacramento, California. 2 officers fired at Clark. He had a cell phone in his hand. Police video, once again, these body-worn cameras captured the shooting along with a helicopter. The officers fired 20 rounds. He was struck 7 times. In the prosecutor's office in Sacramento, California, announced there would be no charges. She had found that the officer had probable cause to stop him and were legally justified in the use of deadly force. The federal government also analyzed it, and they announced they would not file any civil rights violations. And this is kind of one of those extremely heartbreaking, one of the toughest kind of cases for a prosecutor to analyze, because in this case, Mr. Clark didn't have a weapon. He had a gun, but but you can hear in this video, one of the officers yelled gun, his belief that he did have a gun, and obviously he was mistaken. The question is, was it reasonable to make that mistake? So if you'll play that, James.
Fatal police shooting. Officers opening fire on an unarmed black man in his grandparents' backyard. And we are now getting our first look at that shooting. Police, apparently thinking he was holding a gun, now say it was a cell phone. NBC's Gadi Schwartz has our report from Sacramento, and we want to warn you the video you're about to see is disturbing.
Let's just go out the window, running south, running to the south. Officers in a chopper investigating reports of a man vandalizing cars, saying they have a visual on the suspect.
All I can tell is he's got a hoodie on.
A heat signature from the police helicopter camera, the first glimpse of 22-year-old Stephen Clark.
Okay, let's get a perimeter on this. Guy's running.
Two officers below close in.
Stop!
And here is the moment of contact on the ground.
Show me your hands, gun!
In the dark, an officer yells gun.
Show me your hands, gun, gun, gun!
Police firing 20 shots at Clark in his grandparents' backyard, finding no weapons, only a cell phone. Minutes later, one officer says mute, and the two cameras stop recording audio. Clark's family wants to know exactly what was said.
You're muting something you don't want the public to hear what you're saying. And that means that if you don't want the truth to come out, then all of it is a lie.
Sacramento Police Chief Daniel Hahn.
When you saw them turn off the audio there in that clip, what did you think?
I'm just curious why they did that. And so, but I knew that was part of the investigation.
Sacramento has been criticized over use of force against black men in the past. Police confirming in this shooting, one of the officers who opened fire was also black.
Things are heated right now.
It gets
People are
difficult,
angry and hurting and all those sort of things. And I just don't want anybody else to get hurt in our community while we're going through this investigation.
But even with transparency, tonight, a community's frustration still grows. Gotti Schwartz, NBC News, Sacramento.
Hey, NBC News fans, thanks for checking out our YouTube.
And, you know, I present that case because, like I said, that's one of these cases where it becomes extremely difficult. And I can't tell you from that video alone and the couple of facts that are given, whether I think that was reasonable or not reasonable. Much more goes into it. Like I said, George Floyd, that's easy. This case, the issue again is, did they act reasonably? And you can't go with, you can't go be the Monday morning quarterback and say, well, it was just a cell phone. The question was, were they reasonable to believe that he had a gun and reasonable to believe that they had to use deadly force at that time? And that would involve, at least for me, hearing the interviews of what was in the mind of these police officers, enhancing those videos as much as possible to see what they could see, as well as to, see the coroner's report about where he was struck, things of that nature. And so, but those are the type of circumstances that occur for police, as you know, and then the prosecutor's office is then tasked with trying to decide whether charges are appropriate or not. The next case, is an example of sometimes you have cases where charges are appropriate. You look and you think that the police officer did not act reasonably. You do charges, and it still ultimately doesn't end the way you think it should end. This is Samuel Dubois. This is the University of Cincinnati police. Mr. Dubois was stopped on a traffic violation. I think he was missing his front license plate. He was driving under suspension. He was not being cooperative in that. I think what ultimately does is that he tries to drive away from the police officer, and the police officer shoots and ends up killing him. The police officer, in his statement, had indicated that he was being dragged by the car, but that was proven to be false based upon all the video. And this goes back to, one of the things that police agencies now stress, that an individual who's stopped in a traffic stop and drives away, deadly force, you want to avoid using deadly force. That does not necessarily create a life-threatening situation. You don't want him to get away, but for a traffic offense and him driving away, it really doesn't warrant shots being fired. And so we can play, if you would, James, play for about 3 minutes of this video.
Sure. We got about 10 minutes left too, so I wanted to make sure that there were a couple of questions in the chat, but let's play this here. And
okay.
I don't know if there's any audio.
Yeah, the audio will come on. It's one of these cameras where the audio starts probably about 30 seconds into it.
(9233) traffic stop. I'll be on Still Street, just off of Vine.
You by Still Street?
A-firm, Still, just off of Vine.
Joseph Lake.
Okay, we're slow to stop. We're on Rice Street, just off of Still. Ohio, George Lincoln Norris, 6917. Occupied by 1. Hey, how's it going, man?
Hey, how's it going?
Good. Officer Tenzing, UC Police. You have a license on you?
Yeah, what happened? What was the problem?
Okay. Is this your car?
Yeah.
It's going back to a female, actually.
Yeah, my wife, her name is Deshaun DeVries.
Okay. We don't have a front license plate on your car.
Oh, I can come out and live about it. I have it.
What's that?
It's right here. I just...
Oh, okay. Yeah, that's got to go where the front plate's supposed to go.
Well, I didn't know.
You don't have to reach for it. It's okay. You have your license on you?
Yeah.
What's that bottle on the floor there?
Oh, it's a bottle.
Bottle what?
You can smell it. It's
Okay. Do you have your license on you? Okay. Do you know where that license at? Is that or what?
I got my titles and stuff on that.
Okay. I'm gonna ask you again. Do you have your license on you?
I have license. You can take run my name.
So do you not have your license on you? I'm asking you a direct question. Do you have your license on?
I thought I did. I haven't seen it. Why did you pull me over for?
Again, the front tag.
But it's not illegal to have a front flag.
Okay. Actually, it is. I'm going to ask you again. Do you have a license on you?
I have a license. You can run my name.
Okay. Is that not on you then?
I don't think I have it on me.
Be straight up with me. Are you suspended?
No, I'm not suspended.
Why don't you have your license on you?
I just don't. I'm sorry, sir. I'm just gonna go in the house.
Okay. Where do you stay at? Down here?
Right around the corner.
Okay. Well,
John, it's about 3 minutes in. Did you want to continue letting it run? I didn't know.
Just until after the shooting, you can stop it, James.
until I can figure out if you have a license or not, go ahead and take your seatbelt off for me.
I ain't even do nothing.
Go ahead and take your seatbelt off. Stop! Stop! I'm good. I'm good. No, just driving there. Don't get rid.
All right, James, you can stop it there. And this case was evaluated down in Cincinnati by the Hamilton County prosecutor, who stated at the time that the shooting was asinine and senseless. And he said that the victim there, Mr. Dubose, was not acting violently or aggressively. He wasn't listening to commands, but once again, and he refused to get out of the vehicle. But once again, the question is was it reasonable to use deadly force under that circumstance? That police officer, he was with the University of Cincinnati Police Department, but he had left the Ohio State Highway Patrol Training Academy after being there just one day, because they said he couldn't adapt to the physical or mental requirements. They did charge him with murder and voluntary manslaughter. They had two trials, and in both trials, the jury could not come to an agreement. So they could not agree as to whether he was guilty or not guilty. They couldn't reach a unanimous verdict, and the prosecutor's office decided not to try him a third time. based upon talking with jurors in those two cases and seeing that they could not get them all to agree. The officer was released from his job, but then he sued and got a $350,000 judgment for unfair dismissal from his job. So I don't know if he collected. I hope not, but that shows you, even at times, the process you would hope would work, and the prosecutor, I think, made the right call in that case, but they still couldn't get a conviction. All right, so that's what's been going. That these cases, unfortunately, it's dangerous, it's violent, and cases have been going on for years, and will continue as far as police shootings. And I mean, the large majority. I mean, I don't have a statistic, but just having handled in our office are reasonable shootings under the circumstances. But there are those where the police officer is acting unreasonable and deserves to be charged. And one of the things that they've now, not only police officers, but groups have come together to try to help police in their training methods. I know that there was a national group which involved family members of victims of individuals who'd been shot by police, prosecutors, leaders of police agencies coming together to try to come up with policies and procedures. One of those is not shooting an individual who's fleeing in a car. Another is a true focus on de-escalation. For the officer, like in that last case, it would, to give the police officers tools and train them how to de-escalate what can become a confrontational or ultimately an aggressive situation. So, so that's what the rest of the PowerPoint presentation. And I think they ask about a citizens review board, and I think a review board, in my opinion, I think citizens would be crucial factors in that, but I also think individuals who are closer and involved in these cases, be them police officers, victims' family members, prosecutors, defense attorneys. I think a review board that has a combination of individuals with different different backgrounds and different perspectives is a helpful way to try to combat how these cases, one, are handled, but also try to prevent these cases from happening based upon police training. There was also a question about if a person breaks into your home and they start to retreat, you're not allowed to shoot them. Why did the police get off shooting people in the back? And shooting people in the back, a person, whether it's a police officer or anyone who shoots someone in the back, that's an extremely relevant factor as to whether are they truly acting in self-defense. That fact alone doesn't get someone off the hook. If someone breaks into someone's home and they get shot in the back, I'd still think it's likely that that's self-defense if someone's in your home and they have a gun, or they're somehow becoming violent, or you just have a reason to feel threatened. It once again is a totality of the circumstances, and the same holds true for police officers. Shooting someone in the back, it may be reasonable, it may not be reasonable, but it is a factor, and it's usually a factor that goes against self-defense, and it's a factor that goes against reasonableness. But but it's hard to take just one fact and say this is what the conclusion should be. You need to review everything and make a conclusion based upon every piece of evidence you have. And that's why these cases, the public wants to know quickly, what happened. They want to know quickly what's everybody's perspective, what the police believe, what the prosecutor believes, but you really don't want to rush to judgment. You want to make a judgment as quickly as you can. But in even other murder cases that we handle, you want to have all the information so you can make an intelligent and a fair and a judicial decision. So I think that's pretty much my time. I always have more, but it was just at 1 hour. Once again, I think if you have an interest in this, The Attorney General has some interesting information about that, and you can always contact our office with questions or things of that nature. But it's something we don't handle as much anymore. We did handle it, but now it's in the hands of the Attorney Generals. And I think that's a good thing, to have a third party, a completely impartial body handling it. You know, it does at times. I've prosecuted officers for like a sex offense, and it is difficult knowing that I'm prosecuting someone from an agency that I've worked with. You know, it's usually not an officer that I've ever worked with. That'd be too much of a conflict. But it's always nice to bring in or have these things done as impartially and fairly as possible. So thank you for listening to all that. I hope you found some of it helpful, educational. They all involve tragedies, so they're all pretty sad to deal with. But thank you for your time.
Thanks, John. I really appreciate it. And again, if anybody has any questions, ask them in the chat room. I don't know if John's going to stick around, but we can always ask John and at a later date, and maybe the next Wednesday when we meet again, we can kind of revisit and kind of go over some of the questions again. Or if you want to email myself or email Tanya, just reply to the Citizens Academy email that she had sent out. So John, thanks again. Yeah, it's a very difficult situation. Really appreciate you taking the time to explain it. We are going to change to Mr. John Galansky, who's joined us. John's waving there. John is the head of our civil division, and we'll be talking today about what our civil division does. I think during the first week, we discussed the different departments that fall under the Summit County Prosecutor's Office. It's a criminal division, civil and tax. We do juvenile division as well, and our child support enforcement agency. So John's here. John, if you want to kind of do a little introduction of yourself while I pull up your PowerPoint, we'll get started.
James is going to pull up the PowerPoint. We're shifting to a totally different gear, talking about the civil division. And I'm looking out at a lot of names, and I recognize a lot of names. And in the office, I'm always complimented perhaps that I have a lot of Facebook friends. So I see a lot of my Facebook friends out there. Jump in with any questions in the chat. Hope I will be informative tonight. I'm going to try to make civil division law interesting. And I love questions. I love to try to get people involved in civil law. It's not the most glamorous in our office. Obviously, the newspaper doesn't report on a lot of the things we do, but our work is very important. The civil division, who are we and what do we do? So it's me, John Galansky, and we have 8 assistant prosecutors who work under me and 5 support staff. And that's my number, that's my email. If you ever have any questions, email me, call me. I'll try to do the best I can to help you. So clients, so the Summit County Prosecutor's Office, our clients are established by the Ohio Revised Code. So these are our clients. These are the entities that we represent. Now, I'm going to assume most of the individuals on the meeting tonight are from Summit County. So it's kind of unique if we go to the county to the east, I'm going to get my directions right, Portage County, they have a county commissioners, right? They have a treasurer, an auditor, a recorder. If we go to the south, into Stark County, they have the commissioner, the traditional government set up in the revised code. If we go to the north, Cuyahoga County a few years ago changed their form of government to a charter. So the Ohio Constitution allows counties to basically change their form of government to what you've created. So in Summit County, we don't have an auditor, recorder, or treasurer, but we still have the responsibilities to do those tasks. In Cuyahoga County, I believe the only individuals that are elected are the county prosecutor, the county executive, and the county council. So their sheriff is not an elected individual. And there's some controversy. Their fiscal officer, which would be the auditor, recorder, and treasurer are not elected. So when you see these offices up here, in Summit County, this has been our government since 1980, but that's one of the reasons why we have some offices that other counties do not have. And number one is our county council. So what advice would we give the county council? We would advise them what they can legislate on. So we cannot legislate on matters that the state has already legislated, has already made a rule. So a $15 minimum wage, that for some might be a great idea. Everyone might agree that's a great idea. But the Ohio Revised Code sets the minimum wage for Ohio. So we could not make, we don't have the power as a county to make a law that says in Summit County, the minimum wage is $15 an hour. There was, I think it was Cincinnati who tried to do that at the municipal level, and they passed the law. You could always generally pass laws, but then they're challenged later on. So, and one of the other areas that's very controversial is Ohio has prohibited local jurisdictions from passing any gun restrictions as far as the sale or purchase of firearms. That's preempted by state law. So if Cleveland, Akron, or us as a charter county, we basically sit as a municipality, and what we can do, we cannot pass a law to require you to be 25 before you purchase a firearm. So in that instance, the legislature said, and if you do pass a law and somebody challenges it, you have to pay their attorney fees. So we have to be cognizant of our advice to county council. And as an elected officials have a lot of good ideas, right? That's how they got to be elected officials. However, we advise them on what they can and cannot do, not whether we agree or not. So the prosecutor's office, we don't make policy for the county. We advise the policymakers of what their boundaries are. Board of Elections, we just had an election yesterday. It's one of our clients. We attend all the board meetings. There are different issues that come up from time to time. So yesterday, one of the issues, we didn't have a lot of issues yesterday, was under Ohio law, you can file for a application on the day of the election. If you're hospitalized, basically you could file an application, have somebody on your behalf file an application to get a ballot. But the deadline for that is 3 p.m. So Board of Elections says we had somebody come in at 4:05. Well, the deadline is 3 p.m. So we researched it, looked it up. Executive's office, prosecutor's office, fiscal office, engineer's office, judges, health district, townships, sheriff's office, anything that's Summit County, which is truly Summit County. There are things that sound like Summit County. Summit County Bar Association sounds like Summit County. Sounds like a form of government, right? But it's not. Summit County Land Bank sounds like the county, but actually the land bank is a private organization that's filed articles of incorporation with the Ohio Secretary of State. It serves some quasi-public purpose. And then if you look at all these offices, right, we've got a whole list, and there's more. There are times that there was an annexation that was Richfield, the village, Richfield Township, and the county had some responsibilities related to an annexation of property. So the township would be one of our clients, and obviously the executive's office, they're our client, and the county council's our client. So we are what they consider transactional attorneys. So if there are situations where the client's interest might conflict with each other, then we represent generally one of the clients, and then somebody else might represent another client. So in the annexation issue, we represented the county council, and we advised on the annexation process, what their legal requirements were, what the hearing requirements were. We didn't advise whether the annexation should be granted or not. That's sort of a policy decision. We set the legal parameters, and then the township, Richfield Township, was represented by an attorney, a private practice attorney. And now the cities and the villages are considered municipalities. So we don't represent them at all. So we're not the attorney for the city of Akron. We're not the attorney for the village of Lake North. So all those clients, these are what we kind of summarize as the issues that we become involved in. But I could spend an hour telling you about a whole bunch of different issues that we don't have on there. So this is just sort of a summary. Tax foreclosures. So that's a delinquent tax, and we're going to talk a little bit about that at the end. Sunshine law. So I usually get a question, what's a sunshine? Well, it's called the sunshine law because it's supposed to it's supposed to shine on government. We want people to be able to understand what government's doing and when they're doing it, and they could get documents from the government. So we have to advise all of our clients on what's a public record and what's an open meeting. So generally, all meetings of governmental bodies are open to the public. There are some exceptions. During an open meeting, you might be allowed to go into executive session. So if during a council meeting, they were going to discuss settling a lawsuit. So there was a lawsuit that was filed against the county, and the county council was going to consider whether they are going to settle the lawsuit. They could go into, they have to vote in open session to go into executive session. So that sun's not going to be shining anymore, right? Because now we shut off the cameras. Before, we would have everyone exit the 7th floor of the county offices or the county council where the council is located. And then we could have a frank discussion of what the positive reasons why we want to settle a suit and what the negative reasons of what are the, if we don't settle this suit, what could happen. So it's, you want your government to have the legal pluses and the legal minuses. Now, they couldn't make a decision in executive session. They could ask questions. They could discuss with the attorney has to be in executive session in this situation, but they could not make a decision. They couldn't do a straw vote. Okay, does 7 of you think we should do this? It's just limited to information. And then when they come out of executive session, then they could deliberate in open session. So there have been times where they could have gone into executive session, but they didn't, because it seemed to make sense in this situation. If it's something that's really high profile, and if pretty much everyone has all the facts, all the information out there, and there might be some legal positions, so they'll just make they'll settle a lawsuit. It'll be discussed in open session, and then they'll take a vote. Some of the other issues we have that we deal with is bankruptcy. So who is trying to bankrupt what that the county owes? Generally, those are taxes. So if somebody owes back taxes or an LLC owes back taxes, sometimes LLCs are property speculators. They buy up properties. They go into bankruptcy. We would file some actions in bankruptcy court to try to protect the county's interest. And all the offices that everyone saw has employees. So any issue that's an employment issue, we would advise on. We already mentioned the election, zoning. Somebody has a dispute with Job and Family Services over benefits. We collect taxes. There weren't actually, I don't believe there were any tax levies on the ballot countywide, but some of the local authorities had some fire and police levies. So we advise the fiscal office how the money should be distributed between the entities if there are any disputes. Americans with Disabilities Act, so that could be an employment issue, right? We're going to advise as it relates to employment, but that also could be access to the county building, access to the parking garage, intellectual property, sexual harassment, creations of policies. So a good civil attorney will prevent situations from occurring, so it's proactive advice. Now, if you also ask a good civil attorney if their clients always ask for advice before they do something, I think that they would probably say no, they don't. In that situation, we do the best we can with what's already occurred. We review contracts, discrimination claims, type of claims that are filed either before the Ohio Civil Rights Commission, the Equal Opportunity Commission, or with the, could be filed directly in court. The judges, if there are writs filed against judges, if somebody's trying to disqualify a judge, will provide representation to them, which is sort of ironic because I represent Judge Linda Teodosio, our juvenile court judge. And my colleagues argue cases before Judge Teodosio. But remember, we're transactional attorneys as far as the prosecutor's office. We have statutory clients. In some cases, we might ask for an outside counsel to be appointed, but merely because I represented somebody and then I'm before them myself, I could represent a judge on a writ and have a matter before that judge. It wouldn't be proper if somebody filed a writ against the judge to prohibit the judge from doing something, and I was a litigant in that actual case. In that situation, it would probably be problematic. So out of all the clients and all the issues, we always study for conflicts to make sure that there are no conflicts among the clients, even when we're on the sort of the same side. So the sheriff, we had an instance where people might have seen it. So in the domestic relations court, there was a civil protection hearing, and the magistrate had stepped out of the hearing and left the petitioner, she was seeking the protection order, and the respondent, the person it was sought against, in the courtroom by themselves. The gentleman, they started arguing. The gentleman pushed his actually grandmother out of the way and assaulted her. So the county got sued, the sheriff got sued, and the domestic relations judges got sued, the magistrate got sued. So we had different attorneys represent the different entities. We're arguing that we can't, we don't indemnify against criminal conduct. His act was a criminal act. He was searched before he entered the court. He didn't have any weapons. But in that situation, we would sign different attorneys, because you could see the court could say, we don't have anything to do with security. It's the sheriff, right? And the sheriff says, well, you shouldn't have left individuals in the courtroom by themselves. So we guard against conflicts because every client needs to be represented fully, and so we would have different attorneys representing the different clients. So kind of this is a summation, and then we're going to get to a poll question, because I don't know if you did any poll questions, but so we get questions to us. We pursue and defend claims on behalf of clients, but we are asked for prosecutors' opinions. So we have clients who ask for our opinion, and it's a written formal opinion. The Attorney General's office does this as well. The Ohio Revised Code says who we have to give written opinions to. That's 309.09. The Summit County Codified Ordinances say those opinions are public. So if Kathy, because you're right at the screen there, if Kathy wanted to see all of our prosecutors' opinions for 2020, 2021, or 1984, we would provide them to her. And so I'm going to get with a scenario. So situations might arise where no one knows the answer, or we have disputes as to what the answer should be. So although we're not technically an arbiter between those clients you saw listed, sometimes there might be disputes among the clients as to what should occur. So I'm going to give you a factual scenario. As you can see, I'm really excited. I really like being in the civil division because every day it comes up with a brain teaser. And usually my initial gut, we all have gut reaction, right? We should do this, or we should do that, or this would be fair, or that wouldn't be fair. And so I have that. and then we research it. And generally when we write prosecutors' opinions, we have two attorneys research independently of each other, and then they get back together later on so that it's not, you know, someone's gut or it's not being skewed one way or the other, because we're not making policy, we're giving legal advice. So I'm going to give you the facts. The Ohio Revised Code says to be an employee at the Veteran Service Commission, you have to be a veteran. If a qualified veteran cannot be found for the position, then you have to be the parent or the child or the spouse of a veteran. So you have to basically have a close relationship to a veteran or be a veteran. So we'll say 2007, an individual was hired at the Veteran Service Commission. She was not a veteran. She wasn't related to a veteran in the way that I had outlined. And in the meantime, between 2007 and 2015, she didn't become qualified, because obviously she could have become qualified later on. None of those occurred. So in 2015, our internal audit department in Summit County did an audit of the employees at the Veteran Service Commission, and they said, she's not eligible for employment because she's not qualified. So, and you look at the revised code says these are the individuals who are qualified, and she's not that, any of those. She is a civil servant. Once she had survived her probation, which was 6 months, or survives a bad, but once she had satisfied her probation, I think when you're a new employee, you feel survival, right? But when she had satisfied her probation, she became a civil servant. So one client said she has to be immediately terminated. She has to pay all the money back for all the years that and that's the end of it. Another client said, no, well, she doesn't have to pay the money back. She did earn the money, but she can't continue on to employment. All right, so here's our poll question. It's just going to be yes or no. Does she get to keep her job? Yes or no? I like it because it's kind of, the poll's coming out sort of even, because it is a tough question. And I have to give credit to James Pollock for the poll question. He suggested, give him a poll. Because that's what I was doing when I was kind of doing my opinion, right? I was doing public opinion. Do I think this is, so, we got some,
pretty evenly split there, John. It's
yeah,
almost,
it is a tough question. So I initially thought that she cannot work at the Veteran Service Commission anymore. Obviously, none of us are going to think she has to give the money back. She did the work. So I originally said, well, she doesn't qualify under the statute. We can't ignore the statute, right? So we have to, that was my initial take. But I had partnered myself with one of our newer attorneys, first year out of law school. And she researched it and she found quite a bit. And actually the only legal authority we could find basically says, yeah, so somebody put in the chat. Who put in the chat?
Miller, hold on.
All right. They hired her. They know the rules. How did she make it through the interview without this coming up? Those are great questions, Kathy and Celeste. But remember, we get this question later on, probably just negligence. They didn't ask the question, a form one, and in no instance did she misrepresent herself. So that's clear. If somebody she did not misrepresent herself. So the law says once she satisfied her probationary period, she is classified and you can only remove her for cause. So the mistake of the employer cannot be used against the employee. She is innocent in the process. So we issued an opinion and it did resolve the matter. So, but it's kind of a novel because you don't know, you run to one opinion, right? But then taking a look at the law. And I think that was looking at the law and the reason the judges had decided that way. I think that was fair. Right, she said, absolutely. So the final thing we're going to talk about is our tax foreclosure process. So I get this question pretty often. Somebody will look up their neighbor and they'll say, John Golonsky, he's not paying his taxes. And he, not only that, he's a really bad neighbor. And not only that, you know, he has a purple car, right? So I want him thrown out of there. I want a foreclosure filed against him. The one thing we have to remember is when you file a foreclosure against a property owner, somebody has to own that property. So, you know, the county's not in the business of owning property. We own property for our buildings that we're in, but we're not in the business of real estate, of rehabbing. We're going to get to the land bank. That's kind of what they were created for. So after a year of delinquency, the debt, which is called a tax certificate, is sold to a private, basically a private collection agency. And they pay the debt, the face value of it, and they try to collect fees, interest, and they try to get the person on a payment plan. So they get about another year at it. And then after those years, then we would generally file a foreclosure if the tax certificate holder wanted that. So they bought the debt. Now, in some cases, the taxes owed could be less than the value of the property. So they may have made a good purchase with the tax certificate. So they're an investment company, basically. That's why they buy the tax certificates. If we go to foreclosure, the case is filed in common pleas court. And during that whole process, the property owner could set up a repayment plan, pay the taxes. So there are processes where it can be solved prior to the sheriff's sale. So the one thing that's a good thing to close on, because I want everyone to feel positive. You learned about the civil division. 2008, 2009, until today, and today too, we have vacant and abandoned properties. So we have properties. You could go, I live in Akron. Where I live in Akron, there are vacant and abandoned properties. There was one on my street on Allendale. But there are other, Barberton, almost, you could pick out a community and there are vacant. So there's basically, in some situations, it's a company, land speculator, could be a bank who foreclosed, owns the property, doesn't really know what to do with the property, not paying the property taxes. So that would be more likely an LLC. Banks generally would at least say, hey, we got to get rid of this somehow. Or it could be somebody who inherited property. So the property is abandoned. No one's living in the property. They are delinquent in their taxes. So there's a process that we could file a foreclosure, not through court, but through the Board of Revision, which is sort of an administrative agency. We could file a complaint for foreclosure. It has to be certified that it's been abandoned. There's no one living there. It's not that they're delinquent in taxes, which they are only. It's that the property has been abandoned. We serve all the parties that could be served. And this situation also occurs when somebody inherits property. My dad inherited property from his mom in 1976. He inherited it in common with his siblings. For a while, they traded paying the property. No one's living on the property. They traded paying the property taxes. Somebody else dies, right, as time goes on. So who really owns the property never gets transferred. So that's a situation as well. So the fiscal office, Kristen Scalise, she's the one who's owed the taxes. She asked us to foreclose through the land bank or through the Board of Revision. And the property then, if no one files an answer, no one comes in, pays the taxes or comes into the hearing, then the property doesn't go to sheriff's sale. So it's not auctioned off. It's given directly to the land bank. And then the land bank in the 2008, 2009, 2010, they got a lot of money to basically demolish houses. So they got money, there was the Attorney General had a program so they could demolish houses. Now they're more into rehabbing the homes because the property values have gone up considerably, but they'd have to make a determination. They're going to be the owner of the property. They get certain funds to run a land bank. All counties don't have land banks, but it basically takes a problem that you'd have to go through the courts you'd have to go to sheriff's sale, or we could get sort of an expedited. How long can a homeowner defer foreclosure proceedings without paying delinquent taxes? So it's 1 year generally till they get to the tax certificate holder. And then it's a second year, the certificate holder has to work with them. So I guess the short answer would be 2 years. Unless it's been abandoned. If the property is vacant and abandoned, obviously, then it would apply under the land bank process, which in that process, there's no time frame. If it's abandoned, we could do it through the board of revision. We wouldn't have to wait 2 years. Thank you. Hopefully I didn't talk really fast.
But the land bank does do important work where, you know, their goal is to really try to make communities better by, you know, these abandoned, dilapidated eyesores in the communities, which every community sees. You know, the land bank really tries to make it better. And John tries to make it better too.
We try. I want to thank all of you for participating in our Citizens Academy. I think it's a wonderful opportunity. I'm always, as James will say, I'm always happy to share what I do because I really like what I do. I get to work for you, and that's very much appreciated.
You see the question, John?
Yes.
Okay.
Yes. No, I don't know if it's more, you know, obviously there are more homes in urban areas, but if you go out to Coventry or Lakemore, there are abandoned homes there as well. I can't say offhand if I've noted, you know, Green, you know, has become more suburban and less rural. So I can't think offhand of a land bank property in Green. But it's possible as well. So I think that that's rural and urban, maybe not as much suburban, because generally the property values in the suburban areas are a little higher.
But I think we've found that, and I don't mean to go off tangent, I know it's just a little after 7:30, but I think we found that a lot of times in some of what we consider well-to-do neighborhoods, because I think a lot of times people have the perception that these types of homes are only in inner city and only in urban areas, but some of the more higher end communities, people still have the same problems of getting loans that they couldn't afford, and they just get up and leave their home, and it becomes an eyesore. And I think it happens in any community that happens.
To answer the question in the chat, you could contact the land bank and we could provide that information. So you could, and that has happened. People have called me and I said, call the Summit County Land Bank. Sometimes we've looked it up and the property is not delinquent. So it could be abandoned, but it has to be abandoned and delinquent in taxes. And then finally, the land bank, in some situations, the land bank is there, obviously it's there to cure blight, eyesores, to help redevelop neighborhoods, but it's also assisting the property owners in that neighborhood. If your house is sitting next to an abandoned vacant home, it's probably driving down your property value, right? That makes sense. And so I live in Akron's Firestone Park. Our home was broken into, and it was at a time that there was the property had gone through foreclosure, the neighbor's property, and it was in that 08, 09 period. So the bank, whoever owned the property, didn't do any care of the property. And so there's another thing is there's no one looking. If a house is vacant and abandoned, there's no eyes looking. We all have to look out for each other. There's no one looking out for each other if no one's there. So it increases crime when you have vacant and abandoned properties. Generally, it drives down your property values, which hurts our schools because they derive their levies or libraries. You could go through the list if property values are lower. So the land bank is there. It was a tool set up by the Ohio General Assembly to assist communities deal with a unique problem. And that was a long answer to your question. I'm sorry. That's my closing argument. Let's see any more. So thanks, James, for giving the Summit County Land Bank number. And if you have any problems and you feel that, you know, you weren't able, or they didn't ask, you didn't get the information, felt that you know that they effectively responded to, you could certainly email me as well. And I do that. I said, you know, I had spoken to Karen, and you know, she was at our Citizens Academy, and I gave her your number to contact at the land bank. Now, we can't compel the land bank to take on any property, but you know, we certainly can suggest it.
Thanks, John. And again, thank you, everyone. It is 7:35, so we appreciate you tuning in tonight, and have a great night. And like I said, if you have any questions, please email us. We'd be happy to do it. If not, we'll see you next Wednesday. Have a good night, everyone.